Assalamualaikum warahmatullahi wabarakatuh. Today we are going to discuss the judicial review that makes the Supreme Court of the United States of America the most powerful institution in the field of judiciary that has no parallel in any other Western democracy. Now when we define the judicial review, there comes the question, how should we define it? We shall not go any very detail, we shall have only one definition, and that's what I am going to tell you. Power of judiciary to review whether any act passed by Congress or state legislature or any provision of any state constitution or order of government is in consonance with the provisions of constitution is called judicial review. So if some act is passed by some Congress legislation and that is challenged before Supreme Court just check whether this law is in consonance with the provisions of Constitution or not. Similarly, state constitutions, the federating state constitutions, if there are any discrepancies between state constitution and US constitution, then US constitution will prevail, Supreme Court may check it. And next is any executive order passed by President or any subsidiary person, any other person under his command, then it checks whether this order is in consonance with the Constitution or not. So this is the power of judicial review, that it may review the steps taken by executive or the law passed by legislature. So this is the definition of our judicial review. Here comes the question, what are the thought process present in the minds of justices when they are deciding upon some question whether the impugned act is in consonance with the Constitution or not. So it is found that in deciding upon the constitutionality of any act, the Supreme Court does not consider the experience, wisdom or legislative policy of the legislature. You know, legislative policy is important, that tells how the legislation will be done. It will never be checked how experienced and how wise persons are sitting in the legislature. It is just checked. What? It only checks whether the impugned law is in consonance with Constitution or not. The only office that is checked whether the provisions made by the act impugned are in the spirit, in the line of the spirit of the Constitution or not. Only these are the lines whereupon the decision is made. Chief Justice Marshall, the person who actually is the inventor or the discoverer of this judicial review, when he discussed the thought process, how does he think, how does the brother judges thought when they were deciding upon the Marbury versus Madison case. So he told that Supreme Court, it never approves or condemns the legislative act. It does not mean that Supreme Court's office is meant to approve that this is good or to condemn that this is not good. He explains its delicate and difficult office is to consider and declare whether some act is in consonance or in contravention to the Constitution. Having done this, its duty ends. Supreme Court has nothing to do with anything else but to tell, declare, point out that some particular provision of some particular act are not according to law. If they are not according to the Constitution. A particular provision is against the Constitution or transgress the Constitution, then it refuses to give it the power of law. Only this, and nothing else is done. Now comes the question, why judicial review is needed. In the system of British Constitution, you will find there is no such thing as judicial review. The Parliament is supreme, it can interpret its law by its own, so there is no such thing as judicial review. But here in the system of US, actually it was a federation, and there were we could find too much diversity there in the system. So every federative unit was jealous of its own rights, and they wanted to defend their rights against the serpents of big federative units. So there started the day a constitution was devised, and this constitution was actually very vague, or somewhat we say it is very general document, and we have to go for too much interpretation to construe the meanings of this constitution. So and this constitution provides powers to executive, mean president, and legislature, mean Congress, and it gives vast powers in their respective fields. Now sometimes while performing their functions, the legislature, that is Congress, or the president may take extra steps and bring their own meanings to the words of Constitution, and make such law, or may order such decree, or make such executive steps that could be very detrimental to the very foundation of the Constitution. Here, if some citizen finds it that the executive or the Congress have transgressed the boundaries of Constitution, he may challenge it in Supreme Court by petitioning it, and there Supreme Court will check the constitutionality of this step. If it is according to the Constitution, it will be accepted, and if it is against the Constitution, or it is not in consonance with the Constitution, then a Supreme Court may refuse. Balki, I should say that it will refuse to accept it as a law. So this power of judicial review is needed by the system, by the federating system, and almost is present in all federation systems that emulate Western, especially American democracy. Now, question arises whether judicial review was intended to be the part of US Constitution by its founding fathers. We see that President Jefferson was vehemently opposing the phenomena of judicial review. He regarded it to be the violation of the very principle of separation of powers, the principle that provides for three organs and different and separate organs of state: executive, legislature, and judiciary. And this provides, judicial review provides interference, power of interference into the functioning of the different other two parts of the government, judiciary. However, when we go to Hamilton, Hamilton was of the opinion, he intended the Supreme Court to be an effective barrier to the tendencies of encroachment and usurping the powers of others, less powerful units, less powerful federating units. This was the necessary implication that we can derive that President Hamilton really wanted judicial review to be given to the judiciary, and we will reach let's stop it here. We will discuss it further what happens next. Now we check the very constitutional basis of the concept of judicial review. The supporters of judicial review are of the view that if we read the Article 3 and Section 2 of Constitution with Article 6 Section 2, the concept of judicial review will be found clearly implied in these two sections. So we try to find out whether their claim is right. So Article 3 Section 2 reads, judicial power shall extend to all the matters in law and equity arising under this Constitution, the laws of the United States, and the treaties made or which shall be made under their authority. So let's stop here. We say that the judicial power, that is Supreme Court and judiciary, its power shall be extended to all the matters. Which matters? That will arise under the in the matters of law and equity, and arising in three areas under this Constitution. Every matter that is contended and that comes under this Constitution, or every matter that is contended and comes in the purview of any law made by United States or the treaties made by United States. So in these three areas judicial power shall be extended. So now we go to the Article 6 Section 2, which reads, the Constitution and the laws that shall be made in pursuance thereof, and all treaties made under the authority of the United States shall be the supreme law of land. The supreme law of land will be, number one, the Constitution, and the laws that will be made in pursuance of this Constitution. The word thereof means that the laws that shall be made in pursuance thereof, and all treaties made under the authority of the United States shall be the supreme law of the land. So any law that is made in pursuance of the Constitution shall be the supreme law of land, otherwise not. It implies. So when we read Article 3 and Article 6 and their Sections 2, Article 3 Section 2 and Article 6 Section 2 of Constitution together, we find that we need no specific provision to be written in the Constitution for judicial review. Now we find the constitutional basis of judicial review. In this regard, Marbury versus Madison, the case decided in 1803, was the turning point or the point of origin of judicial review. Mr. Marbury was appointed as Justice of Peace of Columbia by President Adams in 1801, but before he could deliver the commission, his term was expired and next president came to the power. Madison was the Secretary of State, and Madison refused to deliver the commission. Hence, Mr. Marbury petitioned Supreme Court for mandamus, as the Judiciary Act 1789 provides that the writ of mandamus may be petitioned before Supreme Court as its original jurisdiction. But Supreme Court decided that the Constitution provided specific things that are part of its original, what we should say, original jurisdiction. And an ordinary law made by Congress cannot extend the Constitution. So the law cannot extend the original jurisdiction of Supreme Court. Hence, the mandamus provision of the Judiciary Act 1789 was ultra vires, was null and void. This is why the writ of mandamus was not issued by the Supreme Court. Now we discuss the assumptions behind the judicial review. Means when the case of Marbury versus Madison was decided, C.J. Marshall set his decision on the following assumptions. He regarded that the Constitution is a written document, and it defines the limits and powers of the government very clearly. So it is the clear-cut characteristic of the American Constitution that it tells that executive will lie with the president and the legislature will lie with Congress, and the judiciary will be responsible for upholding the Constitution and to have a court for the nation. So, secondly, the fundamental law was regarded that the Constitution was the fundamental law. It is the basis of every other law. So, it must be superior to ordinary legislative enactment. As we say that it is actually the, we should say, the consensus of the nation to build a constitution. So, it has a very special way of being amended, prescribed by itself. So it is superior to any ordinary legislative enactment passed by either Congress or by any subordinate, any state legislature. Third assumption was that whenever a situation arises that a law and constitution are contrary to each other, which one should prevail? So, C.J. Marshall assumed and rightly assumed that any law passed which is contrary to the fundamental law, that is Constitution, it will be void, and therefore it would not find the courts to decide according to this law. Now, the last one assumption was that the judiciary, when takes oath, when judge is appointed as a judge or justice, he takes oath that he will uphold the Constitution. And the powers given by Constitution, they demand that courts, when they see that any such discrepancy, any such contradiction is found between the acts of Congress and the Constitution, so it should declare the act of Congress as void. So these were the basic assumptions behind the doctrine of judicial review, and it became the very principle of the American system of judicial working and constitution and lawmaking. Yes, now we discuss the criticism on judicial review. Though the judicial review has become the very much part of the constitutional system of United States of America, however, it is continually receiving the criticism, and these are mainly on these points, that Supreme Court has become a super legislature, which is not the intention of this of the scheme of the Constitution. It is the decision of only one person, as most of the decisions were made by the Supreme Court by a simple majority of one vote. So this is why when it is told that one man is taking decision, it's one man's tyranny that is causing all this. And thirdly, the social progress has been blocked by the Supreme Court. Most of the time, it proved to be such an institution which is not ready to accept the change. So we shall discuss it one by one in our next slides. Now we discuss the first point, Supreme Court as a super legislature. Lasky, a very famous thinker, he says that by assuming the power of judicial review, the Supreme Court has become the third chamber of the Congress. It can check the work of both Senate and House of Representatives. Their bill is brought before it, their act is brought before it, and it decides. So no law can stand as a law, no enactment can stand as a law unless it is approved by the Supreme Court. And the Supreme Court actually becomes a quasi-political institution when it uses the judicial power to decide the constitutionality and justness and fairness of the of any law brought before it. The constitutionality is something that is actually in the domain of the Supreme Court, but when it comes that it is to decide the fairness and justness of the law, then it is not a legal domain. It is actually the political domain where we decide the fairness and justness of any law. So Supreme Court becomes a political institution instead of a legal institution, and it enters in the domain of legislature, and having the power to strike it down, this law brought before it, it becomes super legislature. So you know, when Congress decides some law, it is initiated by some person that leads it, and it has some political philosophy behind it, it has some social philosophy behind it, that some law springs from the two chambers of the Congress. So the same when it is brought before the judges, they do have their own political and social philosophies, and when it is not possible for them to leave their that spectacle away, and to leave their philosophy away, and then decide upon the constitutionality, justness and fairness of the law. So this is why when they cannot be swayed from their political thinking, from their social thinking, they affect the laws. And you can find that judges of Supreme Court handed down the Railway Road Pension Act. Even at some stage, Supreme Court regarded income tax as a sheer assault on the capital. So this cannot allow the change due to their own political philosophy. And similarly, it is said that when Supreme Court validates any law by telling the nation its point of view on how the society and economy should be ordered, so it really assumes the status of a super legislature. It is actually the domain of Congress, of the state legislatures, that they tell how our economy, how our society shall be ordered, and this is done by their enacting the laws. And the Supreme Court strikes down a law, when Supreme Court hands down a law, it gives the nation its point of view, how the USA's society and economy should be ordered. So this is actually not the domain of Supreme Court, but it has given him the status of state super legislature. Mr. Haggs, the CJ, rightly said, we are under Constitution, but the Constitution is what the judges say it is. So the power to explain the Constitution lies with judges, when and unfortunately most of the time judges had a regressive look towards the scheme of the kings, and it produced hindrances in bringing changes in the US world. And the Supreme Court's Judicial Review has brought another type of criticism on it, that it is the tyranny of a few person, of one person. When the laws are brought before the Supreme Court and impugned, and when Supreme Court decides upon it, most of the time it happened that the cases were decided by the majority of one vote in the Supreme Court. So it was said that is actually the tyranny of one person. It is the will of the person, of one person, that is deciding the fate of national policy, that is deciding the national outlook of USA. So the critics really regard it as anything but a democratic arrangement. It is not democratic that only a few judges can surpass, can castigate, can deny the national policy devised by Congress, and they are not ready to accept it as a democratic